Why is it that criminal appeals are taking so long to decide? Why is it that the bar is very eager to decide questions involving bail but not willing to argue criminal appeals? This is doing disservice to our state, the large pendency of criminal appeals. An FIR has been stayed by the Supreme Court, but the accused is not granted bail for over 2 years thereafter. And people are before us asking, please grant me bail. Now, there is a fear psychosis in our district judiciary. Why is the district judiciary so fearful about granting bail? For very long, we in the judiciary have tried to suppress the true facts relating to the judiciary, thinking that it will portray us in a bad light. My view is exactly the contrary. People don't understand that judges work all 7 days of the week. Our district judges work every single day. Even on Saturdays and Sundays, they have to do legal aid camps or have to do other administrative work. Today, we live in times where communication is the mantra, whether it is a social media, whether it is WhatsApp. And as part of the judiciary, we cannot be left behind in this new world of communication. Let us look beyond just judges in the canvas of arbitration. Let us broaden the canvas of arbitration by getting people who are acceptable, engineers, chartered accountants, young members of the bar, senior members of the bar. I thought I shouldn't speak from a prepared text for this morning and speak from the heart for a few moments. The initiatives which we showcase today reflect both on the past and the present of the High Court of Judicature at Allahabad. They reflect on the position of this High Court in the life not only of the state of Uttar Pradesh, but of the entire nation. They represent a vision for the future. So in coining all that we have done in terms of the infrastructure for this great High Court, in preparing the book called The Courts of Uttar Pradesh, we dwell on what Uttar Pradesh is today as a legacy of what happened in the past and the past on which we have built so much, the past which we have discarded to a certain extent, because all our courts began in the legacy of the colonial period. The colonial period reminds us that law can be used as an instrument of justice, but it can be also used as an instrument of oppression and injustice. It depends on whose hands the law is wielded. You had the same Indian Penal Code, which was used from 1860 and which we still use today until the new legislation is enforced. But the same law which was used to jail the freedom fighters, to torture the opponents of the regime, is hopefully being used today to protect the rights of citizens in the hands of an able bar, which we have in the Allahabad High Court, fiercely independent lawyers, judges who have come from the bar and from the services, who use that law to dilute the rigors of the power of the state. So this is clearly a reminder to us that it is for our generation today to ensure that the excesses of the past, most of them prior to independence, but many of them even after independence, such as during the years of the emergency, are not replicated against in free India. These initiatives today are also the product of people who have gone before the present generation. I know that Justice Bhosle, who is here, was the moving spirit behind Courts of India when he constituted the committee during his tenure as the Chief Justice. Justice Bhosle is truly a people's man. As Brother Mishra was telling me, he is always present always for every important occasion of the Allahabad High Court. I have to learn something from his book because I'm coming back after 8 years. But 8 years was too long for me. So what we are unveiling today represents our vision for the future of the Allahabad High Court. Let me briefly dwell with each of these initiatives and share a few thoughts which I have today. We have inaugurated the Arbitration Center of the Allahabad High Court. We have provided a venue for the arbitrations to take place. For those of you who have done little work on arbitration, you know the distinction between the venue of an arbitration and the seat of the arbitration. What we have provided is an efficient venue for arbitration. But is this center only a venue for arbitration? Arbitrators otherwise go and sit in 5-star hotels. They go and sit in centers for arbitration. To my mind, the setting up of the arbitration center at Allahabad is venue plus, to use today's terminology. Of course, it provides a venue. It provides a place where people can come and congregate. And in providing that beautiful space, I must compliment all the judges of the Allahabad High Court, the people in the Public Works Department who have collaborated with the High Court in setting up the center. We have conference rooms, we have huddle rooms, we have a locker room, a cafeteria, everything that is required for a day of arbitration. But there's something more. And that is where I would like you to develop this whole concept. First and foremost, I'm extremely pleased to learn that the name of the center is not the High Court of Judicature Allahabad Arbitration Center. It's called the Arbitration Center Prayagraj. Why? What is the significance of it? Is it just another name? No. Calling it the Arbitration Center of the High Court would give the impression that it is an arm of the Allahabad High Court. That it's an arm of the state, because we are not part of the government, but we are all part of the state, the nation state. The business community in particular always has some reservations when arbitration is associated with the imprimatur or the stamp of the state. Because the essence of arbitration is party autonomy, the independence of parties. That's why they choose their own judges. In the High Court or in the Supreme Court, our lawyers don't choose the judge. They will appear before. Though I've also found that there is a bit of forum shopping which goes on. But lawyers don't choose the judge. In arbitration, litigants choose their own arbitrators by nominating their own arbitrators because they have faith in those arbitrators. And the presumption is that arbitrators who are nominated by litigants are not their mouthpieces. That is simply theoretically the foundation of arbitration. So the idea of having an arbitration center called the Prayagraj Arbitration Center is to truly indicate that this is a center of arbitration which is not dependent either on financing or support from the High Court. So the High Court stands behind this initiative. We as judges are facilitators. We stand behind this initiative. But in creating this venue, we also want to create a process of arbitration which is efficient. Efficient in terms of cost, efficient in terms of timelines for arbitrations. If arbitrations were to take as long as a suit takes in a court, then why would people go to arbitration? If they have to spend as much as they have to spend in a suit, why would they go to arbitration? Setting up this center is also a sign of accountability, that arbitrators have to be accountable to the community whom they serve. They can't be accountable if they sit for 2 hours and charge the fee for the whole day. I know I have been criticized for having interpreted the 4th schedule to the Arbitration and Conciliation Act as imposing a cap of 30 lakhs on the fees which arbitrators can charge. Our mission in literally interpreting the provisions of the statute was to ensure that this is what Parliament has laid down. If you want to alter the provisions which have been made by Parliament, Parliament is free to do so. But we also said that you can charge for a counterclaim and a claim separately, because a counterclaim is a separate suit. One of my learned brothers felt a little differently on counterclaims. So we are not just replacing one form of dispute resolution, namely resolution in court, with another form of dispute resolution, namely court-style resolution in the hands of arbitrators. In the choice of arbitrators, most of the arbitrators today are retired judges who, of course, do a remarkable job. All of them are very highly experienced. But let us look beyond just judges in the canvas of arbitration. And that is where I want to appeal to all the learned and respected senior members of the bar who are present here. Many members of the bar do not become judges for a variety of fortuitous circumstances. Maybe you are not asked at the right time. Maybe a person whom you felt is a competitor got elevated to the bench a little before you. Maybe there were family circumstances bearing on economic resources. Many people join the bar late because they have had to combat personal difficulties in the early part of their lives when they took jobs somewhere else, and when the situation stabilized financially for the family, they took to the bar. So they didn't become judges for a variety of reasons. But the wealth of experience which our senior members of the bar have today can surely be contributed in the arbitration space. When I have to impose costs in the Supreme Court, I'm always very wary, because my assessment of costs is very different from what the realistic costs today of litigation are. Very often when I impose costs, the lawyers laugh and they say, please allow us to give you a realistic assessment of costs. So you as members of the bar know the feel of reality on the ground, which we as judges over a period of time may not necessarily have. And I do believe that by setting up the arbitration center, we can encourage more and more members of the bar to contribute to the arbitration space. We can train the younger members of the bar. This will be a training ground for them to become judges of the High Court in future. I have found, for instance, when I appoint a lawyer in their 30s or then their early 40s as arbitrators, many of them complete the arbitration in record time efficiently as a call of duty to the court. So in the choice of arbitrators, let us broaden the canvas of arbitration by getting people who are acceptable: engineers, chartered accountants, young members of the bar, senior members of the bar. Because these are people who have the voice of the community, who have the faith of the community. So all in all, so far as the arbitration center is concerned, it is important now to frame rules for the arbitration center. Create a society which will be professionally managed and professionally run. And the entire arbitration center should be handed over to a professional body of persons consisting of judges, consisting of lawyers, consisting of eminent citizens of Prayagraj who have distinguished themselves in different walks of life, so that by professionalizing this center for arbitration, we will indicate that as judges of the High Court, we stand behind this center. Of course, this is all due to the vision of today's judges. But while we stand behind this initiative, the success of the initiative will lie in how much we really are able to professionalize arbitration within the state of Uttar Pradesh. Brother Bindal rightly mentioned, how much it will be used is a moot point. But let us also remember that we are today using a facility. The premises of the High Court of Judicature at Allahabad were set up over 100 years ago. So those who created that infrastructure had the vision to create infrastructure which could be used even 100 years later. So when Justice Bindal and his committee decided that instead of having a VIP guest house, we will have an arbitration center, this has been done with a great amount of foresight. Irrespective of how much it is used today, we have created a seed for the future. Uttar Pradesh is attracting investment. as the state grows from a predominantly agrarian economy into a market-based industrial economy, there will be bound to be more and more trade, commerce, investment coming into the state. And trade, commerce, and investment relies on certainty. It relies on the rule of law. It relies on the existence of objective standards for dispute resolution. In creating this, we are sending the message across to the community that what happened in the more developed states like Maharashtra or Karnataka or elsewhere in the country is now being replicated in terms of infrastructure and rule of law, which will sustain the confidence of our communities in the new horizon which we would like to create for this state. So I compliment everyone who has been associated with this new infrastructural growth in the High Court of Judicature at Allahabad. The second aspect which I want to stress upon today is the importance of the infrastructure which is being created for the district judiciary. The district judiciary truly is the cornerstone of the administration of justice in every state in the country. The district judiciary is the first point of contact when a citizen has a problem, whether she has a dispute about maintenance, whether she's been thrown out of her house by in-laws and she has to seek a remedy under the Prevention of Domestic Violence Act, or when senior citizens have to move for securing their own rights in the face of a family. So the district judiciary is the first point of interface of our citizens. But here I have a few concerns which I must share with you. My first concern is the large pendency of criminal appeals. Brother Mishra, Brother Manoj Mishra, Brother Pankaj Mittal, Brother Vikram Nath and I, all of us belong to the judiciary in Allahabad. We all belong to Allahabad. Some of us may have different birthmarks. My birthmarks go to Maharashtra, but I belong to Allahabad as well as I do belong now as the Chief Justice to the entire nation. Across our court, judges constantly voice this concern. Why is it that criminal appeals are taking so long to decide? Why is it that the bar is very eager to decide questions involving bail but not willing to argue criminal appeals? I think all of us need to sit together to resolve this issue, because this is doing disservice to our state, the large pendency of criminal appeals. This is not undoable. This is not a situation which has gone out of control. Several other states in India, including the state of Tamil Nadu, had the same problem which we have today, but they found solutions to the problem. Now, what happens because of the large pendency of criminal appeals, particularly in the High Court, is that judges are compelled to grant bail, particularly in the Supreme Court, no matter how heinous the offense is, because of the realization that if you don't grant bail today, the person will probably die in jail or have served out the sentence by the time that the criminal appeals comes up. That's not good for the system either, because you no longer just look at the rights of the accused, you also look at the victims of crime. But we as judges have no choice but to grant bail for the simple reason that we realize that these appeals will never come or see the light of the day. But this has another consequence, which is of equal greater concern to me, which is the inability of our courts to grant bail to under-trials. Repeatedly in the Supreme Court, and I am not giving you Newtonian science, small offenses, petty offenses where people have been in jail for 1.5, 2 years as under-trials, they run to the Supreme Court to grant bail. We have dealt with cases where an FIR has been stayed by the Supreme Court, but the accused is not granted bail for over 2 years thereafter. And people are before us asking, please grant me bail. Now, there is a fear psychosis in our district judiciary. And I'm sure both the judges and the members of the bar will agree with me. And I'm not being critical at all. How can I be critical? I'm here because of my life as a lawyer, and I'm here because of my life as a judge. So I'm not being critical. But I'm asking you to introspect. Why is the district judiciary so fearful about granting bail? The district judiciary is fearful about granting bail because over a period of time, we have created a culture of subordination between the high courts and the district judiciary. We have not created a footing of equality between the district judges and the high courts. You know, the whole process of inspection, the administrative judge, it wreaks fear in the minds of the district judges. When you look at the young judges who are joining the district judiciary, and in my tenure as Chief Justice of the Allahabad High Court, I traveled across the state. I found a marked difference. The younger generation of judges in the district judiciary, so bright, so full of hope, they would talk to you as if they were talking to a friend or a member of the family. The more senior judges, so sober, so quiet, so withdrawn, you had to draw them into a conversation. They would be very reluctant to speak to you. So that shows you the difference between the young and the old, in the senior in the district judiciary. I think that has to change, and the duty to do that lies on us as judges. So this culture of subordination has to change. We are having a conference in Kutch in the next few weeks, where we are inviting about 150 to 200 district judges from all over the country to talk to me and my two senior-most colleagues about what the district judiciary feels needs to be done for them. We want to hear their voices, and hopefully we will have a conference thereafter in the Supreme Court, having about 800 or 1,000 district judges from all over the country. The idea is to hear their voices, allow them to speak, allow them to tell us without a sense of fear. I'm very happy to know that the infrastructure of the district judiciary is going to be improved by having 10 integrated court complexes in 10 different states, in 10 different districts in Uttar Pradesh. Our court should not be known by the reeky old infrastructure, by the absence of toilets for women, by the absence of facilities. You'll be surprised. I was administrative judge of Kolhapur years ago when I was a judge of the Bombay High Court. When I went there, I was told that there was one toilet for women judges in the entire district court in Kolhapur. If they had to use that toilet, they had to go past a corridor where all the under trials and convicts who came to court for the hearings of their cases were sitting. And the women judges told me that we feel so awkward to pass them and then go to the toilet that the senior district judge women, the ADJs, told me that these girls leave home at about 8 o'clock in the morning. The next time they use the toilet is at 6 o'clock in the evening when they go home. This reflects the reality of our system. Therefore, in the Supreme Court, we have tried to attend to this by creating toilets for women, by ensuring that every toilet for women has a sanitary napkin dispenser. How are we going to create a working space for women which is accessible, which is welcoming of them? In many states, including Uttar Pradesh, the new recruits to the district judiciary, over 50% are women. The new lawyers who are coming into our system because of the spread of education. Yesterday, we inaugurated the first session of the Rajendra Prasad National Law University at Prayagraj. So we have 2 national law universities today, with a large number of women coming into the legal profession. Young women are being encouraged by parents to come into the legal profession. Many of them are joining the district judiciary because the district judiciary gives them secure conditions of work. You don't have to face the uncertainties of private practice at the bar. But it is our duty then to create conditions of work, dignified conditions of work for them, so that they can flourish as members of the district judiciary. Recently, I've been dealing together with Justice Pardiwala and Justice Manoj Mishra with issues pertaining to the revision of the conditions of service of the district judiciary. Though a new pay commission would now be set up and would be looking into the conditions of service of the officers of the central government, and thereafter, of course, the states will follow, we are still in the process of implementing the previous recommendations of the pay commission of our Judicial Pay Commission. We have now provided a timeline for the payment of arrears of salary, the arrears of allowances. But most importantly, and that's what I want to highlight, we have also directed the setting up of a permanent mechanism for overseeing the implementation of recommendations for the district judiciary in every state. A simple thing. Judges from the district judiciary in Uttar Pradesh came to the Supreme Court and they got up, just 2 or 3 judges got up and say a few things. And they said that we have one small issue. If hospitals have to be identified for giving cashless treatment, usually tenders are invited because you have to go for the L1 bidder. The L1 bidder is usually a person a hospital who wants to work on volume and not on quality. So the L1 bidder will be usually a hospital which will cut the corners in the medical treatment so long as you get the contract by being the lowest bid. They said, sir, this has to change because nobody has faith in those hospitals across the districts. We have to ensure that our district judges, their families, their parents who are dependent on them, our retired judges, are able to have proper medical treatment. Because you require medical treatment only in your later years of life, generally speaking, though there are, of course, exceptions to that rule. So we have set up a permanent mechanism to ensure that proper medical facilities are available to the members of the district judiciary. These are crucial initiatives. And I think it's important that members of the bar are also involved in appearing before the court. Some of the best ideas which I get when we are dealing with issues pertaining to the district judiciary are from young members of the bar, be it from Uttar Pradesh, be it from Bihar, be it from Madhya Pradesh, be it from other states who come to us and tell us what the state of the judiciary is. Recently, the Supreme Court has brought out a compilation called The State of the Judiciary. And we have tried to make an outreach. For very long, we in the judiciary have tried to suppress the true facts relating to the judiciary, thinking that it will portray us in a bad light. My view is exactly the contrary. It is when we point out facts pertaining to the judiciary, to the nation at large, that the state of affairs within the judiciary itself will improve. So whether it be in terms of bringing out a Supreme Court Chronicle, every month the Supreme Court of India now brings out a Supreme Court Chronicle, which is also being translated into Hindi. The idea is to tell the nation, what is it that the Supreme Court does? What is it that the judges of the Supreme Court do? We communicate in terms of important judgments which are pronounced during the course of the month. But I also request my colleagues to share with the Center for Research and Planning all the legal aid initiatives which they do, the lectures which our judges deliver, the camps which they attend. Because let the community know the nature of the work which judges do. You know, all of us are criticized for the vacations which we have. They all say, inko chitti bahut zyada milti hai. People don't understand that judges work all 7 days of the week. Our district judges work every single day. Even on Saturdays and Sundays, they have to do legal aid camps or have to do other administrative work. But why does the community not know this? The community does not know this because we do not reach out to the community. We feel that as judges, we should not be part of the community because our independence may be affected. True, we don't mix around with people who have cases before us, which is correct, to preserve our own independence. But the times when we should stand away from the community have changed. Today we live in times where communication is the mantra. Whether it is a social media, whether it is WhatsApp, whether it is a messaging service, we today live in an age of communication. And as part of the judiciary, we cannot be left behind in this new world of communication. We have to imbibe that world of communication, not at an individual level. Individual judges should not be putting out things in the social media, but we must institutionalize the process. In the Supreme Court of India, we have now set up a communications division. The idea behind setting up a communications division in the Supreme Court of India was because of a popularly held feeling on the part of journalists, on the part of other citizens, that if we have to have information about the Supreme Court, whom do we access? if we do not have a point of access to information, then information about the courts is usually obtained behind the doors or behind the scenes. And then the information is garbled, it is half-hearted, it does not reflect the entirety of the truth. So therefore, we as courts need to reorientate ourselves. We need to reorientate our way of thinking. We also have to be careful about the pitfalls. As you all know, we are now live streaming of cases, which is being shown on the YouTube. But live streaming of cases on YouTube also places new burdens on us. In the earlier years, what we said in the court was only seen and heard by 50 people or 100 people in the court. Now what you say or hear in the court is relayed to the entire nation and beyond. So that places a very great burden on judges to be correct in what you speak, to be very careful in off-the-cuff remarks, because everything that is said by us can be interpreted and misinterpreted, and is being interpreted and misinterpreted constantly. So it requires more training on the part of judges, for judges to understand what the new demands of the system place upon them. Last part I want to dwell very briefly, and then I'll be done, which is on technology and justice. I want to really tell you, all of you, that technology is not really a new-fangled idea of this Chief Justice who has interest in technology. What is the idea behind technology as part of the justice delivery mechanism? All the showcasing that you saw by the High Court of Judicature at Allahabad, I'm so glad to know that the digitization project which I initiated in 2015 has grown so much. You'll be surprised that when we took over that building just behind the Allahabad High Court and went into the basement, on the first day, Justice Dilip Gupta and I were told, please don't go inside the basement because we have found snakes in that basement. We were told that the basement cannot be restored because the water table in Allahabad is much higher. And I said, well, they construct tunnels across the sea. Why are we talking about not having to use the basement? And we have proved what can be done when you apply your mind to it. But what is the idea behind all this? Why digitize files? Why have live streaming? Why have paperless courts? Is it just to sort of make the court processes more tech savvy? No. The idea of doing all this in a technology-friendly way is to make us first more efficient as judges, but most important, to take the work which we do to the lives of our citizens. And technology is a very key instrument in ensuring that the work which we do does not remain aloof from the community, but takes it right to the heart of the community. So when we set up e-Seva Kendras, as I've been propounding all over the state, we ensure that the digital divide which exists in our country even today, the poorest of the poor, the marginalized who come to our courts seeking access to justice for the acquisition of a small piece of land, they are not deprived of technology or access to justice because they don't have an Android phone or a smartphone. So the idea behind setting up e-Seva Kendras is to ensure that all the services under the e-Courts project are available to every citizen, that nobody suffers because of a want of digital divide. In my court, in the Supreme Court, every file is digitized. We do not have paper in the Supreme Court. When we decided the Article 370 issue several months ago, the total record was probably in excess of 30 to 35,000 pages, all available at the click of a button. Imagine 5 judges trying to seek volume 45 of 500 pages and being constantly handed over these volumes when the arguments were going on. Instead, each of us had all the volumes open on one screen. And when the lawyers shift from volume to volume, all that we do is that we switch from one window to the other. And I'm so happy to tell you that even senior colleagues who are on the verge of retirement were so eager to adopt technology because they felt that this was their opportunity to be equal with the younger generations, both in the family and beyond, that they are themselves able to access technology. For the senior members of the bar who are present here, I always encourage senior members of the bar, please start using your iPads. Please start using your laptops. It will be so much easier for you. Technology does not make your life difficult. It makes your life simple. And increasingly, I've been finding all the youngsters at the bar are tech savvy, but even the senior members of the bar are now imbibing technology as a part of their functioning and work. So we have e-filed the files. We have an e-filing module in place in the Supreme Court. We are digitizing all our files. Most importantly, the files which are digitized and are now available in the electronic form are given to the lawyers so that the lawyers and the judges are on the same page when they address arguments before the court. We have the Suswagatam portal, which we launched recently in the Supreme Court. So all passes to come to the Supreme Court, which is a high security zone generally, all passes are now available online. You don't have to wait and queue up in line to get a pass to come to the Supreme Court. All the formalities, including your identity document or whatever that you have to upload, you just upload the details and you get a pass online. So some of these hybrid hearings have been a potent source of social transformation. Because I believe that with hybrid hearings, the Supreme Court has ceased to be the Supreme Court of Tilak Marg, and it has truly become the Supreme Court of India. When I have a young lawyer addressing us from Kochi, or a young lawyer who appears before us from another part of the country, I feel that this is really the opening up of the democratic space of the Supreme Court for lawyers from all over the country. And why is it important? At a certain level, it's important because we are fostering confidence in the members of the bar and the litigants. The lawyers in the district, the lawyers in the High Court have the immediate contact with the client. When the client goes up to them and they have conducted the case for several years, and if they were to argue the case before us in the Supreme Court, that lawyer has a sense of satisfaction that my lawyer who knew my case has now been able to present my argument before the Supreme Court. And I dare say the same before the High Courts. Therefore, I've been constantly appealing to the High Courts, please don't shut down the infrastructure which we created during the COVID-19 pandemic. Infrastructure for technology was meant and used in COVID-19, but it has to last longer. Let us not stop e-filing. Let us not stop hybrid hearings. You'll be surprised with the number of women who appear today through hybrid hearings. And the reason why women appear through hybrid hearings is because you don't have to wait all day waiting for your case to reach. Women perform multifold responsibilities at home, which men should be. Many of them do perform it, but women traditionally in our society perform so many different roles. So by creating the space for hybrid hearings, we have allowed women to participate in an equal measure in the workforce of the legal profession and the bar. So all in all, I'm so happy with all these initiatives which have been launched today by the High Court of Judicature at Allahabad. It truly marks the progression of Prayagraj into becoming a model for the judiciary across the nation. Earlier, when I was the Chief Justice of the Allahabad High Court, we used to send our judges to see the initiatives which were launched in different parts of the country, a new judicial academy, a new digitization program, a new arbitration center. I'm sure with this now judges from other parts of the country will be coming to Allahabad to model their institutions on what we are doing over here. Last and not the least, I want to tell you that if I've spoken from my heart on some critical issues which concern the judiciary, it is not out of a sense of criticism. I owe everything to Allahabad. When I came here, I was a completely urban-born and urban-bred product from a city like Mumbai. I'd, of course, spent a part of my formative years in Delhi, but I was predominantly an urban-centric and urban-born product. So my attitude as a judge, my vision as a judge, my knowledge as a judge was shaped by what I learned in my birth state, if I may call it that, Maharashtra. When I came to the heartland of India, Uttar Pradesh, I looked at the country in a very different light. I saw the woes of farmers in a different light while dealing with the sugarcane cases. I would see land litigation in a very different light after I sat with very experienced judges, understanding the nuances of the the ZA and LR Act. I looked at motor accidents cases very differently when I sat with colleagues who had a bearing about the nature of income and income earning capacities in our districts in Uttar Pradesh. So UP in that sense really gave me a completely different insight into the life of the nation, for which I will always remain grateful to you. When I came here, I was told, when I came here, I was told, be careful about the bar in Uttar Pradesh. The lawyers can be a little aggressive. But when I came here, I found that the lawyers were so kind. They were so respectful. They were so welcoming. And they were willing to accept the slightly younger Chief Justice from Maharashtra who had some new ideas to give to them. But one thing which I realized was that if you're objective, the lawyers would accept any verdict that you handed down to them. I particularly used to appreciate the senior members of the bar who would argue a very contested case, maybe in the law of education or cooperative societies or whatever, or labor. After you sort of raised your hand and indicated that I want to now call the steno and dictate my judgment, the lawyers would sit down with grace. The more busy of them would tell you that, may I go to the next court? My case has been called out in another court. And I would say, please go ahead and I'll dictate the judgment in your absence over here. So coming here was a very great surprise for me, because everything that I was warned against when I came to Allahabad proved to be untrue. And I had my own experiences of a very happy 3 years that I spent here in the company of all of you. I, of course, had my fair share of 2 or 3 strikes, but I also learned from some of those strikes as well. I also learned the big secret that never allow a strike to continue for very long, because the strike begins on one issue and ends on some other issue. So happy years here, a lot of learning in the company of judges. I'm so happy that many of the judges with whom I had the pleasure of hearing as lawyers are now adorning the bench. I find it a great sense of satisfaction that they are all doing so well here in the Allahabad High Court. I always tell my colleagues in the Supreme Court that before you assess or evaluate an order of the Allahabad High Court, please understand the pressure under which that order is written. Pressure in terms of the volume of work, no other pressure, just the volumes. Everything in technological terms is scaled up in Allahabad. If a judge in some other high court has to hear 10 anticipatory bails a day, a judge in Allahabad has to hear probably that 10 raised to the power of God knows how many. So wishing you all the best. Thank you very much for inviting me here. And I hope to be here again. Thank you.